Welcome to this episode of Subro Sessions. I am David Huberman, a partner at White & Williams, and I'm a member of the subrogation department. Today's Subro Sessions will focus on certain instances where an additional insured under a builder's risk policy could be a viable subrogation target, notwithstanding the anti-subrogation rule. So you get a new loss involving an ongoing construction project and a builder's risk policy or a policy with a builder's risk coverage endorsement. If you're anything like me, you immediately think to yourself, who is my insured? Are they the project owner? Are they the general contractor? Or are they some other entity related to the project? What kind of project is it? Is it commercial, residential? Is it a school? Is it a hospital? I like to know what type of project I'm dealing with. The next question is, what happened? What kind of loss is it? What is being reported regarding the cause of the loss? Who are the potential targets? What are my theories of liability? Is there an incident report that I can review to get a better handle on the facts? And of course, what written contracts exist? In all construction losses, contract review is critical. And why is that? Because you must identify all risk-shifting contractual terms that may affect your ability to subrogate. The most notable risk-shifting contractual term is the waiver of subrogation clause. A waiver of subrogation clause in a construction contract shifts all risk to an insurer and bars an insurer's ability to subrogate. If a waiver of subrogation provision exists in the contract, you must carefully review the specific language. Who is specifically waiving subrogation? Who is the beneficiary of the waiver? Is it a mutual waiver, or does the waiver run only one way? Are there any ambiguities in the waiver language? Is there any case law in the jurisdiction interpreting the scope of similar waiver language? While this type of analysis is a critical component of analyzing recovery potential of a construction loss, it is not the main focus of this podcast. Best practice is to obtain key project contracts that could factor into your analysis. This includes the prime contract, a construction management contract if the project has a construction manager, and architects and engineers contracts. It also includes relevant subcontracts. And do not forget about the general conditions accompanying some of these contracts. General conditions are often incorporated by reference into the prime contract. It's the next prong of the analysis that this podcast is about. And that is not to say that there is any particular order that you need to follow when you are performing your analysis of subrogation potential of construction-related losses. The next prong of the analysis requires the careful review of the applicable builder's risk policy. Why is that important? Because you want to determine if the policy expressly insures the interests of others besides the named insured. By this, I mean subcontractors, subcontractors, architects, engineers, material suppliers, product manufacturers, etc. So it's important to get a complete copy of the applicable builder's risk policy with all policy endorsements. Now I want to turn to additional insured language in a builder's risk policy. Obviously, not all builder's risk policies contain identical language, but oftentimes these policies contain language specifically naming various entities or classes of entities who may qualify as additional insureds under the policy. For instance, the definition of an additional insured in a builder's risk policy may sound something like when any named insured is party to a written contract or agreement that requires owners, contractors, subcontractors, architects, engineers, manufacturers, suppliers, or any other legal entity to be identified as an additional insured for a project. This policy includes the legal entity as an additional insured, and then only as to their respective interests in the project. If you were listening closely, there was qualifying language in the definition. One qualification involved the named insured being contractually required to obtain coverage for various third parties working on the project or supplying materials for the project. The other qualifying language was, quote, and then only as to their respective interests in the project, end quote. Sometimes this language is written as an acronym, ATIMA. ATIMA is a common phrase in insurance policies that extends coverage to other parties who may incur a loss if the insured property is damaged or destroyed. This phrase is often used in insurance policies to show that the entity who is named in the policy has some kind of insurable interest in the property that is being insured. This interest may not be specified, but it means that the entity is entitled to benefits if something happens to the property. Going forward, we're going to focus on the ATIMA qualification relative to additional insureds and its relationship to the anti-subrogation rule. However, for purposes of our discussion, we're going to make a couple of assumptions. The first assumption is that there was a contractual requirement for the named insured to procure insurance for other entities. The second assumption is that we've identified a subcontractor as a potential subrogation target, and that subcontractor is an additional insured on the policy. As some of you may know, the anti-subrogation rule provides that an insurer has no right of subrogation against its own insured for a claim arising from the very risk for which the insured was covered. This is black letter subrogation law. The first rule of subrogation is that you cannot subrogate against your own insured. This rule applies to builders' risk insurers as well, but with one exception that is recognized in several jurisdictions. It's this exception that we're going to be discussing in detail now. For purposes of our discussion, I want to discuss St. Paul Fire and Marine Insurance Company versus FD Sprinkler, which is a case coming out of the First Department Appellate Division in the state of New York. St. Paul, a builder's risk insurer, paid about $714,000 to its named insured for property damage caused by an unintended sprinkler discharge during a construction project. St. Paul filed suit against two subcontractors, FD Sprinkler and Woodworks Construction, for causing the loss. At the trial court level, the court granted summary judgment for FD Sprinkler based on the anti-subrogation rule. At the appellate level, the court acknowledged that FD Sprinkler and Woodworks Construction were additional insureds pursuant to an endorsement on a builder's risk policy. The policy contained language providing coverage to all subcontractors as their interests may appear. The court reasoned that the ATIMA language provided the subcontractors with protection only to the extent of their property interest in the building under construction, which essentially was their tools, labor, and materials furnished or owned by that subcontractor. The court went on to say that the policy did not provide the subcontractors with coverage for any damage they may have caused to the property in which they had no interest. In other words, FD Sprinkler and Woodworks Construction did not have an insurable interest in the entire project. The court pointed out that $52,000 of the $714,000 paid by St. Paul was to repair Woodworks' work. To this end, the court noted that this specific damage, the $52,000, was indeed barred by the anti-subrogation rule. However, the rest of the indemnity payment made by St. Paul was recovered. The St. Paul case was a favorable ruling for builders' risk insurers, but hinged on the ATIMA language in the policy. The ATIMA language essentially limited the subcontractor's insurable interest in the building. Thus, it also limited the application of the anti-subrogation rule. Hypothetically, if the subrogation target in the St. Paul case was the general contractor would have had an insurable interest in the entire project, and the ATIMA language probably would not have circumvented the anti-subrogation rule. Now, keep in mind that the St. Paul case was decided by a New York appellate court in 2010 under New York law, and its precedential value is strongest in New York State. However, some courts in other jurisdictions have reached similar conclusions. It's important to note that there is a split of authority on whether the term "as their interests may appear" in a builder's risk policy should be allowed to pierce the anti-subrogation rule. Some courts are unwilling to carve out an exception to the anti-subrogation rule based on the ATIMA qualification. Other courts have held that a builder's risk insurance policy includes a named insured's negligence as an insurable interest, even if the policy contains the limiting language "as their interests may appear." So the main takeaways from this podcast: Subrogation analysis in the context of a builder's risk claim can be complicated. There are multiple issues to analyze to determine the viability of subrogation. Do not assume the anti-subrogation rule categorically bars claims against a responsible subcontractor who is also an additional insured under the builder's risk policy. Depending on the policy language, certain jurisdictions may permit a builder's risk insured to subrogate against a negligent subcontractor for damages outside the responsible subcontractor's scope of work or material supplied on the project. So, to wrap all this up, when you get your next construction loss involving a builder's risk policy, in addition to your standard contract analysis, ask yourself, who is the subrogation target and are they an additional insured under the applicable builder's risk policy? If the subrogation target is an additional insured under the policy, are they an additional insured only to the extent as their interests may appear on the project? If yes, what are their interests in the project? In other words, what is their scope of work on the project? Their scope of work is key. For example, a drywall contractor that strikes a sprinkler head. The drywall contractor's interest in the project may be limited to the sheetrock they hung and their labor, tools, and materials. Another example, a plumbing contractor who makes up a poor solder joint or fitting connection and a flood occurs. The plumbing contractor's interest in the project may be limited to the installation of water lines, pumps, hot water heaters, boilers, etc., as well as their labor, tools, and materials. Another example, a flooring contractor who causes a fire by the improper disposal of stain-soaked rags, causing a spontaneous combustion fire. The flooring contractor's interest in the project may be limited to only the labor and materials related to flooring work. And here's the last example. If your subrogation target is the project's general contractor or the project architect, you might not be able to parse out a narrowly defined interest of either. Arguably, each may have an interest in the entire project. Finally, ask yourself, did my loss occur in a jurisdiction like New York that permits an exception to the anti-subrogation rule for damages outside the interests of the responsible contractor? Or are you in a jurisdiction such as Louisiana that does not recognize this carve-out? This is important. If you are not in a jurisdiction that adheres to the exception to the anti-subrogation rule in the builder's risk context, you are probably out of luck. However, if you are in such a jurisdiction, there may be a path to a recovery, assuming you catch some breaks along the way, such as the absence of a contractual waiver of subrogation. The subrogation target is an additional insured as their interests may appear, and the target's interests in the project are limited to a narrowly defined scope of work and specific labor or materials. Thank you for listening to this episode of Subro Sessions. You can find past episodes of the podcast on the White & Williams homepage, www.whiteandwilliams.com. Hover over the Insights link and select podcasts to find past episodes.